everyone. I warmly welcome you all to today's special class by LiveLaw Academy. Today's session is on jurisdiction of the criminal courts, inquiries and trials, part 1. Before we begin, it is both my honor and privilege to introduce the guiding force behind this session, Justice V. Ramkumar Sir, our patron and chief mentor at LiveLaw Academy. Justice Ramkumar is a distinguished former judge of the High Court and is our patron and chief mentor at LiveLaw Academy. He had started his journey through his LLB from Government Law College, Mumbai, and enrolled as an advocate in 1979. In 1987, he was directly recruited as a district and sessions judge. Sir later served as law secretary to the government of Kerala and was elevated as a permanent judge of the Kerala High Court in 2004, a position he held with great distinction until his retirement in 2012. Over the years, Justice Ramkumar Sir has also served as the chairman of the advisory board under the Kerala Anti-Social Activities Prevention Act, as well as the ombudsman for the Kerala Cricket Association. He is a much sought after speaker, regularly invited by judicial academies, law universities, and the Bar Council to address judicial officers, prosecutors, and students. His contributions to legal literature, including acclaimed books like Law of Prevention of Corruption, Tendering Pardon to an Accomplice, and Magisterial Trials, Law and Procedure, his unique question and answer style legal articles on live law have helped decode tough concepts for students and practitioners alike. And now, without further ado, let's all welcome Justice Ramkumar Sir and begin this most interesting session and the part 1 of this session. We welcome you, sir.
Thank you, Vishalakshmi.
Thank you, sir.
Vishalakshmi, now, as it is not that interesting, this topic is slightly dry and slightly boring also, but very important topic because the jurisdiction of the criminal court, or rather jurisdiction of the magistrate, is coterminous with the jurisdiction of the police station and vice versa. Jurisdiction of the police station is coterminous with the jurisdiction of the magistrate. That is how the section is drafted. In fact, if you see section 1, let me check. This BNSS is causing a lot of confusion for me. It was an unnecessary statute replacing. If at all any amendment was necessary, the sections in the CRPC could have been amended. Right. Old wine in new bottle. Right. 156 CRPC corresponding to 175 of BNSS. 156 1 corresponds to 175 1 of BNSS, which says, see the wording, that is where you get this position. I'll 175. I'll read just 175 1.
Sir, should I read out section 175, subsection 1?
Yes.
Police officers' power to investigate cognizable offence. Section 175, subsection 1 reads as follows.
Yes.
Any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of Chapter 14.
See, there lies the catch. Any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of Chapter 14. Now, we are right now going to Chapter 14 of BNSS, which defines the jurisdiction of the criminal courts. Now, 175 1 says the police station will also have the same jurisdiction which the magistrate having jurisdiction over the area has. Therefore, it is like co-terminus, the co-extensive. The jurisdiction of the magistrate or police station is co-extensive with that of the magistrate. That is why the CRPC contemplates the fixation of the various police station limits within the jurisdiction of a magistrate. Supposing there are three magistrates in a particular station. Magistrate 1, court 1 number 1, court number 2, court number 3. Court number 1 is given a few police stations. So, if any occurrence takes place within the local limits of any of those three police stations, that court number 1, magistrate number 1 alone can try the offence. It is co-extensive. Likewise, certain other police stations might be given to court number 2. Therefore, if any occurrence is taking place, any crime is taking place within the limits of any of those police stations assigned to court number 2, then court number 2 alone will have jurisdiction to try the offences. This is how the police station and the magistrates are linked by section 175 1 CRPC corresponding to section 156 1 I am sorry 175 1 of BNSS corresponding to section 156 1 CRPC. So we are now going to consider the jurisdiction of the magistrates, criminal courts, for the purpose of inquiries and trials. What do you mean by inquiries and trials? We are going to consider what exactly is an inquiry, when does it start, and when does it stop, and when does the trial start, when does the trial end. Only when you know the demarcating line, they are almost watertight compartments, not fully, but almost watertight compartment. When investigation stops, inquiry begins. When inquiry stops, trial begins. This is how it is schemed under the CRPC as well as BNSS. So, first is investigation by the police or any other agency having power to investigate. Then, after investigation, if it is a police officer, he will file a police report, charge sheet, or refer report before the magistrate. Then the investigation stops. There the investigation ends. Investigation is concluded with on the conclusion of investigation, the police officer in charge of the police station will file a police report before the magistrate. So investigation stops there. Then what takes place before the court is inquiry. On the materials produced by the police, the magistrate will consider the materials and either discharge the accused or frame a charge against him. Before that, the court will take cognizance of the offence. After considering the police report, the court may take cognizance of the offence. When cognizance of the offence is taken, that is the first stage when the criminal court, after considering either the police report or a private complaint, does. What the magistrate does is taking cognizance of the offence, that is, taking judicial notice of the offence, discernible either from the police report or from the private complaint. Once he takes cognizance of the offence, he will issue process to the accused, and then the accused will come. So, courts have taken the view that the right of the accused to address the court or participate in the trial only when he receives summons. Summons is the invitation given to the accused to appear before the court and participate. If before that stage, before the issue of process, the accused is present in court, Supreme Court has taken the view that he can only watch the proceedings. What is taking place in the court? He can only watch. He cannot participate in the occurrence because he is yet to be invited to the court by the issuance of a summons or warrant. Therefore, he has no locus standi to address the court unless and until he receives summons. So, even if he happens to be present in court, he can only watch the proceeding. What is going on here? I am made an accused. It seems I am told that I am made an accused, but he has no right to participate in the trial. So this is the distinction between investigation, inquiry, and trial. Once the charge sheet has been filed or private complaint has been filed, the court will consider the private complaint or charge sheet along with the materials produced along with the police charge or police report or charge or private complaint, and then court will take cognizance. And then if the court issues process, then only the trial can take place. And until process is issued, to the accused, it is inquiry. So investigation, it stops with the filing of the police report. Then comes the inquiry. The magistrate applies his mind to the police report and considers the materials, takes cognizance, and issues process. There ends the inquiry. Then comes the trial. This is the main distinction between these three. Of course, I will take you to the finer distinctions. So, in fact, in the procedure for inquiry and trial for Indian Penal Code, that is BNS procedure, Section 4 of CRPC corresponding to Section 4 of BNSS says that the procedure for investigation, inquiry and trial for all offences under the Indian Penal Code, that is BNS, shall be the procedure available under the BNSS. Whatever procedure is laid down by the BNSS shall be applicable to all offences under the BNS, that is formerly Indian Penal Code. But then there are other offences under other statutes like Prevention of Corruption Act, the Arms Act 1959, Explosive Substances Act, Explosives Act. There are other statutes wherein also there are offences. So what is the procedure for trial of those offences, for investigation of those offences, for inquiry in respect of those offences? CRPC Section 4.2 corresponding to Section 4.2 of BNSS says, now see Section 4.2. I will read Section 4.2. I will read rather 4 itself, entire Section 4.
Sir, shall I read it?
Oh, please.
Section 4, subsection 1 reads as follows. All offences under the Bharatiya Nyaya Sanhita 2023 shall be investigated, inquired into, tried and otherwise dealt with according to the provisions hereinafter contained.
See, all offences under the Bharatiya Nyaya Sanhita, formerly Indian Penal Code, they shall be investigated, inquired into and tried as per the BNSS only. Then comes subsection 2.
All offences. Yes. All offences under any other law shall
be... Any other law. That is any law other than BNS, IPC. Yes.
Any other law shall be investigated, inquired into, tried and otherwise dealt with according to the same provisions, but subject to any enactment for the time being in force, regulating the manner or place of investigating, inquiring into, trying or otherwise dealing with such offences.
So, other offences also. 4.2 says, Section 4.2 says, other offences shall also be investigated, inquired into and tried as per BNSS, unless any of those other offences prescribes a different procedure. If the special law prescribes a different procedure, then with regard to that procedure, the court will have to make a departure. Otherwise, it is BNSS itself is the procedure prescribed for other offences also. For example, a court of session can take cognizance of an offence under Section 193, is it not? Section 193 CRPC corresponding to Section 213 BNSS only upon a committed. A magistrate has to initially consider the case and then commit the case to the court of session under Section 193 CRPC corresponding to Section 213 BNSS. But there are various statutes like Prevention of Corruption Act, other statutes wherein special courts which are deemed to be court of session, special courts which are deemed to be courts of session are to try the offences. They are basically, for example, SC/ST Atrocities Act. SC/ST Atrocities Act until 2016, it was the Section 14 of the SC/ST Atrocities Act said before the amendment. Now it has been amended. Before amendment, the section said the state government may specify a court of session to be a special court for trial of offences under this SCST Atrocities Act. That was the section. In compliance of that section, in various states, the state governments notified or specified an existing court of session to be a special court. It did not prescribe the procedure for the special court because basically it is a court of session. So if it is a court of session, the procedure for a court of session under the CRPC, that is BNSS, will have to be followed. But in one case, a full bench of the Kerala High Court held that being a special court, it can take cognizance without an acquittal, without a committal. The Kerala High Court, a full bench of the Kerala High Court held that being a special judge, he can take cognizance of the offence without a committal under section 193 CRPC. Now, Supreme Court said nothing doing. Speaking through Justice K.T. Thomas in Gangula Ashok versus State of Gujarat, State of Punjab, I think, State of Andhra Pradesh. That is 2000 Supreme Court. I don't remember the page number. AR 2000 Supreme Court, Gangula Ashok versus State of Andhra Pradesh. Supreme Court, speaking through Justice K.T. Thomas, held that no, it may be a special judge, but what does Section 14 say? Section 14 says the state government may specify a court of session to be a special judge, to be a special court. So basically, it is a court of session. In the absence of any special procedure prescribed by the SCST Atrocities Act, you have to follow the procedure under the CRPC, namely Section 4.1, 4.1 and 4.2. So CRPC alone will apply. Therefore, the special judge cannot take cognizance without a committal. That was the view taken. Of course, after that, now the special court can take cognizance without the accused being committed to it. So now the special court, which is a deemed special sessions court, can take cognizance of the offence without a committal. So that is the distinction. 4.1 and 4.2. 4.1 says IPC offences, BNS offences shall be inquired into, investigated and tried according to BNSS. 4.2 says other laws shall also be inquired into, investigated and tried according to BNSS only, except to the extent the special law makes a departure. Now, SCST Atrocities Act in the year 2016 made that departure. Until then, it was a court of session only. But with the amendment of SCST Atrocities Act, it became a special court wherein a special procedure was described. That procedure is it can take cognizance without a committal. That is how the law has been evolved. That is the importance of Section 4. Now, let us examine the scope of the expressions inquiry and trial. We are dealing with the power of the criminal courts for conducting inquiry and trial. What is an inquiry? When does it start? When does it stop? Now, please read question number 1 under inquiry. Inquiry. Yes.
Sir, our first question is, what is an inquiry?
Exactly. What is an inquiry? Now, Section 2G CRPC, corresponding to Section 2K of BNSS, defines the word inquiry as follows. Inquiry means every inquiry. Inquiry means every inquiry other than a trial conducted under this Sanhita by a magistrate or a court. It does not make any head or tail. Every inquiry means every inquiry. Does it make any sense to you? Inquiry means every inquiry other than a trial. So it is not a trial, certainly, but it is an inquiry conducted under this Sanhita by a magistrate or a court. But the above definition does not indicate the commencement or termination of the inquiry, and therefore such a definition is of no use, no practical use to any of us. Then inquiry under CRPC, BNSS is in Lalita Kumari, the constitutional bench in Lalita Kumari versus Government of UP, AIR 2014, Supreme Court 187, 5 judges, speaking through Justice P. Sadashivam, who was then the Chief Justice of India. Year 2014, Supreme Court 187, corresponding to 2014, Volume 2, SEC, page 1. It held that inquiry under CRPC is a judicial exercise undertaken by the court and not by the police. Therefore, inquiry is only by the court, not by the police. Police do not have any power of inquiry. But even that has been watered down by the courts themselves. The judge made power of preliminary inquiry given to a police officer before the formal registration of an FIR. That was also approved by Lalita Kumari, by the Constitutional Bench in Lalita Kumari. Because way back in 1971, Sarafuddin versus State of Madras, it was held that in corruption cases, it is always better to have a preliminary inquiry conducted by the officer in charge of a police station before a public servant is, before a crime has been, FIR is registered against a public servant, because incalculable harm will be caused to the public servant if an FIR is registered against him without a preliminary inquiry, at least by the police. That was the view taken. That view has been approved and approved, ultimately reaching in the Constitutional Bench in Lalita Kumari. Lalita Kumari, however, made one departure. In Sirajuddin, what was held was, if you don't conduct a preliminary inquiry before registering an FIR, incalculable harm will be caused to a public servant who is doing public service to the. See, there may be so many disappointed, disgruntled elements who might not have been able to curry favors from a public servant. Therefore, they may be waiting for an opportunity to institute vexatious prosecutions against him. Therefore, the Supreme Court in Sirajuddin versus State of Madras held that before registering an FIR, there should be a preliminary inquiry conducted by the investigating officer, by the officer in charge of a police station, to see whether there is some material, prima facie case for registering an FIR. That position was followed by the Supreme Court in various decisions. Ultimately, it resulted in Lalita Kumari. But Lalita Kumari made some departure. Of course, preliminary inquiry is a must in cases where, in corruption cases, etc. But the scope of preliminary inquiry is not to find out whether there is any veracity, whether the allegations are true or not. Court cannot, the SHO, Station House officer cannot look into the correctness or otherwise of the allegations. If he is satisfied that there is the allegation of commission of a cognizable offence, he is bound to register the FIR. He cannot go further to examine whether the allegations are true or false. The veracity of the allegations cannot be looked into. Therefore, if a beautifully drafted first information has been given to the public officer in charge of a police station, even if it is a false case, he has to register a crime. That is the settled view by Lalita Kumari. Departing from the earlier view. Now, after Lalita Kumari, he has to register an FIR under compulsion, so long as the allegations are there regarding the commission of a cognizable offence. Supposing the allegations do not make out a cognizable offence, then he can conduct a preliminary inquiry to find out whether there is a cognizable offence alleged. Then the Supreme Court catalogued a few category of cases where also preliminary inquiry can be conducted. For example, corruption cases, then matrimonial offences, then this bank, some commercial transactions. In such cases, Supreme Court, the Constitutional Bench approved the conduct of preliminary inquiry before the formal registration of a crime. But then, when does the inquiry start? That there's a observation by a constitutional bench of the Supreme Court in Hardeep Singh versus State of Punjab, AIR 2014 Supreme Court, 1400, 5 judges, corresponding to 2014, 3 SEC 92. The 5 judges, or the verdict is authored by Dr. B.S. Chauhan. In paragraph 25 of the Constitutional Bench ruling, AIR, it is observed as follows. I quote, the stage of inquiry commences insofar as the court is concerned with the filing of the charge sheet and the consideration of the materials collected by the prosecution that is mentioned in the charge sheet for the purpose of trying the accused. So when does the inquiry start? As per the Constitutional Bench, Hardeep Singh's case, stage of inquiry commences so far as the court is concerned with the filing of the charge sheet. That means with the filing of the charge sheet, investigation is over. Investigation is over with the filing of the charge sheet. Then inquiry starts. Inquiry starts, and how does the inquiry start? With the consideration by the magistrate of the police report and the materials collected by the police in support of the police report. When the magistrate considers those things, he is said to be conducting an inquiry. Then in paragraph 5 of a Kerala decision, State of Kerala versus Achyuta Panikkar, 1975 KLT 703, 1975 KLT 703 by Justice S.K. Kadir, who was a great judge on the criminal side. The High Court of Kerala observed as follows. The proceeding up to the point of framing a charge is in the nature of inquiry. So, inquiry starts with the consideration of the police report and the materials as per Hardeep Singh's case, and proceeding up to the point of framing of charge is in the nature of inquiry. Inquiry stops when trial begins. So, inquiry starts when the magistrate considers the police report and the material. It will go on till the commencement of trial. Once the trial starts, inquiry stops. So investigation starts with the registration of the FIR and the commencement of investigation, and investigation stops with the filing of the police report. Then the stage is for inquiry by the magistrate. Inquiry will start with the consideration of the police report and the material, and it will go on till the framing of charge. Once the charge is framed, the inquiry stops and trial begins. This was the view taken by the Kerala High Court also. Again, in paragraph 9 of Moli versus State of Kerala, AR 2004 Supreme Court 1890, AR 2004 Supreme Court 1890 corresponding to 2004 4 SEC 584, 2004 volume 4 SEC 584, the Supreme Court, speaking through Justice Arijit Prasad, observed that trial is distinct from inquiry, and inquiry must always be a forerunner to trial. Trial is distinct from inquiry, and inquiry must always be a forerunner to trial. So, trial comes after inquiry. Same thing. Similar observation was made by Justice Arijit Prasad in Vidyadharan versus State of Kerala, AR 2004 Supreme Court 536, corresponding to 2004 volume 1 SEC 215. There also the same observation as obtained in Moli versus State of Kerala was made by Justice Arijit Prasad. But these two decisions, namely Moli versus State of Kerala and Vidyadharan versus State of Kerala, were overruled by a 3-judge bench on another point, not on this point, on another point. There, in these two cases, the special judge under the SC Atrocities Act tried the case without a committal. There was no committal because full bench of the Kerala High Court had taken the view that there need not be a committal. It was following the full bench decision. In these two cases, the special judge tried the offence under the SC Atrocities Act without a committal and without any objection or demur by the accused. Accused did not raise any objection in terms of Gangula show, Justice Thomas view. Therefore, the trial continued and he was convicted. Then, in an appeal against conviction, he raised this point for the first time, Gangula Ashok's case, and held and argued that I was tried without a committee. I was tried by the special court without a committee. The Supreme Court accepted this argument in both these decisions. But a three-judge bench of the Supreme Court in Rati Ram versus State of Madhya Pradesh, year 2012 Supreme Court 1485, year 2012 Supreme Court 1485, corresponding to 2012 Volume 4 SCC 516, three judges. They overruled this Moli and Vidyadharan to hold that if the trial was conducted without a committal, but without any objection from the side of the accused, if he had participated in the trial without demur, then you can't say that the trial is bad. It is only a curable irregularity. It will not vitiate the trial. So saying, the three-judge bench overruled that aspect of Moli and Vidyadharan. But the observation regarding inquiry in Moli and Vidyadharan still holds good. Now, please read question number 2.
Yes, sir. The second question is based on the prerequisite that whether the following proceedings amount to inquiry. The question is test identification parade conducted by a magistrate.
Test identification parade, which is usually called TIP. Whether TIP conducted by the magistrate during the stage of investigation can be said to be inquiry. After all, it is taking place before a magistrate. Therefore, the question is whether it is an inquiry. No, it is not an inquiry. TIP is conducted to ascertain the participation of the person in the occurrence by parading him along with persons having similar physical appearances and features, thereby enabling an eyewitness or a victim to identify the assailant, if any, during such parade, which falls under Section 9 of the Indian Evidence Act 1872. That is corresponding to Section 9 of Bharatiya Sakshya Adhiniyam, BSA. Since TIP is conducted only during the stage of investigation, it has been held that it is not an inquiry. It is not an inquiry. Please read para 9 of Harnath Singh versus State of Madhya Pradesh, year 1970, Supreme Court, 1619. 1619. A constitution bench, 5 judges, constitution bench. Again, para 13 of Madhuru versus State of UP, 1971, volume 2 SEC, page 75, by the author is I.D. Dua, Justice I.D. Dua. Identification tests, it may be pointed out, do not constitute substantive evidence. Such tests are primarily meant for the purpose of helping the investigating agency with an assurance that their progress with the investigation into the offense is proceeding on correct lines, on proper lines. That is the purpose of TI parade. Therefore, TI parade is not an inquiry. It is only conducted during the investigation, only as an assurance to the police officer to ascertain whether he is proceeding on proper lines. Supposing he has caught a person as the accused, but he is not the accused, but somebody else is accused. The victim or an eyewitness may be able to identify the real assailant in a TI parade. Therefore, if he identifies the correct person, correct assailant or culprit in a TI parade, then the investigating officer can proceed by arraying that person as an accused, so that he knows that he is now proceeding on proper lines. That is the purpose of TI parade. Therefore, it is not substantive evidence at all. Again, you may refer to Santokh Singh versus Izhar Hussain, 1973, volume 2 SEC 406. 1973, volume 2 SEC 406. Again by Justice I.D. Dua. still, yet again, Justice Sadashivam, in that notorious Siddharth Vasisht alias Manu Sharma versus NCT of Delhi, AR 2010 Supreme Court 2352. Supreme Court speaking through Justice P. Sadashivam held that TIP cannot amount to an inquiry since it is conducted during investigation. Now we pass on CIP. First question is whether test identification parade is an inquiry. No, it is not an inquiry. Now we come to the next question. Question 3.
Question 3 is, after registering an FIR for a cognizable offence, the SHO arrests the accused and produces him along with the copy of FIR, remand application, entries in the case diary, etc., before the nearest magistrate. After perusing the records, the magistrate remands the accused to judicial custody. Is it not inquiry?
See, an FIR is registered against a person. During the investigation of that case, that person is arrested. And the arresting officer produces him before the magistrate, nearest magistrate, along with the FIR and copies of the register of the entries in the diary, etc., which is a requirement under section 167 CRPC, is it not? Under section 167, it has to be produced the accused has to be produced along with the entries in the diary. So it is then the magistrate peruses the diary, the remand application, FIR, etc., and remands the accused to judicial custody. Is it not an inquiry? Magistrate is applying his mind. Magistrate is applying his mind to the FIR, the entries in the diary, remand application, etc. The accused is also in front of him. Is it not an inquiry? No, it is also not an inquiry because this is a proceeding taking place during the stage of investigation. Therefore, it cannot amount to an inquiry. Then, next question number 4.
Question 4. Is recording of the confession of an accused under section 164 subsection 4 of CRPC in correspondence to section 183 subsection 4 of BNSS or the recording of a statement of a person by a magistrate under section 164 subsection 5 of CRPC corresponding to section 183 subsection 5 of BNSS as the case may be done during the course of an inquiry?
Now see, under section 154 CRPC, corresponding to section 183 BNSS, the magistrate has two functions. The earlier part of section 183, that is 183.4, subsection 4 of BNSS, the magistrate can record the confession of an accused. An accused can volunteer and can enter the court to the magistrate and volunteer to make a confession. He need not be sponsored by the police. That is what the Supreme Court said. An accused can walk into the magistrate's court and say, I am an accused in such and such case. Of course, the magistrate will have to get it verified through the public prosecutor, APP. If he is an accused in a pending investigation, he has a right to make a confession to the magistrate. So the magistrate, he can say, I want to make a confession. The magistrate can say, okay, let me check up. Then after checking up, the magistrate finds that he is an accused in a pending investigation. Therefore, he can permit the accused to make a confession. Only requirement is the magistrate should be satisfied that the request for making a confession is voluntarily made. Voluntarily made, that is on his own accord, without any compulsion, without any extraneous influence. If the accused says, I want to make a confession, I don't, because I have got the prick of conscience. I did commit this offense. Now the prick of conscience tells me that I should confess, because yesterday I confessed before the Lord Subramanya or Lord Mahavishnu. So today I want to confess before Your Honor, my prick of conscience does not permit me to say that I did not to tell a lie. Therefore, I want to make a confession. If the magistrate is satisfied that this statement of the accused is voluntarily made without any extraneous influence, he has to record the confession under section 164(4) of CRPC corresponding to section 183(4) of BNSS. Then the very same section, subsection 5 of the very same section, gives power to the magistrate to record the statement of any person. Statement of a person can be a witness, can be a victim, can even be an accused, not a confession, but just a statement. A non-confessional statement can be given by an accused. So if the accused wants to make a non-confessional statement, or if a statement of the witness, prosecutor, the investigating officer may make a request to the magistrate that here is a witness who may turn hostile to the prosecutor in due course because he is a near relative of the accused or he is a friend of the accused. So he may turn hostile to, he is an eyewitness. He may turn hostile to the prosecution. So kindly, when his memory is fresh and when he is not vacillating, please record his 164(5) statement or 183(5) statement. Then he has to be sponsored. That's what the Supreme Court initially, through Justice K.T. Thomas, held that if he is a witness or victim, he has to be sponsored by the police. A victim or witness cannot straightaway walk into the magistrate's court and say, my statement may be recorded under section 183(5). No. The magistrate will ask him, are you sponsored by the police? If you are not sponsored, you cannot. So if he is sponsored by the police, then the witness or victim can make a statement under section 164(5) CRPC. He will have to be administered oath. Oath can be administered to him, but not to an accused when recording a confession. But if it is a witness or victim, the magistrate can administer oath and record his statement under section 183(5) BNSS. During the question is whether this is done during the course of an inquiry. Takes place before the magistrate. Supposing it is a statement of a witness, even oath is administered to him. Question is whether it is an inquiry. Answer is no. Section 164(1), that is section 183(1) of BNSS, itself says that confession or statement made under this section is to be recorded during the course of investigation or at any time afterwards, but prior to the commencement of inquiry or trial. Section itself says prior to the commencement of inquiry or trial. Therefore, the recording of a confession of the accused or recording of a statement of a witness is taking place at the stage of investigation and prior to the inquiry, and therefore it can never be part of an inquiry. It is not an inquiry. The earliest decision is that of Bombay High Court, a full bench of the Bombay High Court, Emperor versus Purushottam Ishwar Amin. AR 1921 Bombay, page 3, full bench, corresponding to ILR 45 Bombay 834. All English judges, except one Shah. The author of the judgment is Pratt, P-R-A-T-T, Pratt. It has held that recording of the statement of a witness under section 164(5) CRPC, it was only CRPC then, is not done during the course of a judicial proceeding, and such a statement does not constitute evidence even. Because evidence, as you know, is always recorded in the presence of the accused, not behind his back. Therefore, it is not even evidence. That is the view taken. Subsequently, there is a beautiful judgment by Justice Desai, Chief Justice Desai of Allahabad High Court then, Shio Raj versus State, AIR 1964 Allahabad 290, full bench, the author of the judgment is Chief Justice Desai, where it was held that a magistrate exercising power under Section 164 CRPC is not acting as a court while recording evidence with regard to because if it is a court recording evidence, it should be with regard to a fact and issue or a relevant fact. But it is not recording evidence when a magistrate records the statement of a witness under Section 164 subsection 5 CRPC. Therefore, it was held that he is not acting as a court. In fact, he follows the Justice Desai has followed a Privy Council decision, that is Nazir Ahmad versus King Emperor, AIR 1936 Privy Council 2532. AIR 1936 Privy Council 253. Lord Roche is the author. It was held that even though a magistrate recording a confession under Section 164(4) CRPC was not acting as a court, he, being a judicial officer, was bound to strictly comply with the prescriptions under Section 164 CRPC while recording a confession, and that if the magistrate had not complied with the requirements of Section 164 CRPC, he was not entitled to give evidence regarding the alleged confession made by the accused. The beautiful statement of the law. See, before recording a confession, the magistrate should be satisfied that it is voluntarily made. Secondly, he should warn the accused that, look here, you are not bound to make a confession. Even if you make a confession, the punishment prescribed for the offense is this. I can award the maximum punishment on you. Therefore, just because you make a confession, don't expect any lenience. You are not bound to make a confession. All these requirements have to be satisfied by the magistrate before he records the confession. Even after telling this to the accused, the accused has to be given some time for reflection. The magistrate has to give the accused some time for reflection. He has to reflect upon what the magistrate told him. Usually it is 24 hours time given. The accused is sent back and called next day and asked, I told you yesterday you are not bound to make any confession. Even if you confess, this offense is punishable with imprisonment for so many months. I can, for the offense committed by you, I can award you that much punishment. You don't expect any leniency in the punishment. All these things the magistrate can take. Say, and did you consider all these things? Yes, the accused says, yes, I was reflecting on what your honor told me yesterday, but my prick of conscience tells me that I have to confess. I don't want to tell a lie before this honorable court. Therefore, I want to confess. Appropriate punishment may be awarded to me. In such a case, only the magistrate. So, therefore, the Privy Council held that, speaking through Justice Roche, Lord Roche, held that unless the requirements of Section 164 have been satisfied, if those requirements have not been satisfied in the given case, even the magistrate cannot be summoned, or even if he is summoned, he cannot speak about the confession recorded by him if he has not complied with the requirements of Section 164 CRPC. And he is not acting as a court. Even though he is a judicial officer, Privy Council held that he is not acting as a court while recording a confession. So, this is also not inquiry. Now we come to next question. Question number 5.
Yes, sir. Question 5. Since the power to add a person as an accused under Section 319, subsection 1 of CRPC, corresponding to Section 358, subsection 1 of BNSS, can be exercised even during the course of an inquiry, is it permissible for a court to exercise the said power during the course of an inquiry under Sections 200 and 202 of CRPC, corresponding to Sections 223 and 225 of BNSS?
I told you that inquiry relying on Kerala decision as well as Supreme Court decision, Molly versus State of Kerala, etc. Inquiry starts with the filing of the charge sheet, is it not? Once the charge sheet is filed, investigation stops. Investigation is over. Inquiry starts with the filing of the charge sheet and the consideration of the charge sheet by the magistrate. The magistrate will have to apply his mind to the charge sheet and the documents produced along with the charge sheet. This is inquiry. So inquiry starts with the filing of the charge sheet and it goes on till commencement of trial. So here is a case where in a private complaint, the sworn statement of the accused is recorded under section 200 CRPC. Accused is not before the court. Accused is yet to be summoned under section 200 CRPC corresponding to section 223 PNSS and under section 202 CRPC corresponding to section 225 BNSS. The accused, the complainant, the sworn statement of the complainant and his witnesses are recorded by the magistrate. After taking cognizance of the offence, the magistrate records the sworn statement of the complainant and his witnesses for what purpose? For the purpose of ascertaining whether there is sufficient ground for proceeding. Whether there is sufficient ground. The purpose of an inquiry under section 202 CRPC, that is 225 BNSS, is to find, he has already taken cognizance. Once the magistrate, I have told you in the earlier classes, once the magistrate applies his mind for the purpose of proceeding under chapter 15 CRPC, chapter 15 CRPC, that is section chapter BNSS, chapter 16 BNSS, starting with section 223 BNSS, that is section 200 CRPC. Once the magistrate decides to proceed under chapter 15 CRPC, he is said to have taken cognizance of the offence. The offence is already taken cognizance of. He has taken judicial notice of the offence. Then he has to be further satisfied that for issuing process, that there is sufficient ground for proceeding further. It is for that purpose that he conducts an inquiry under section 202 CRPC. And there can be cases where after recording the sworn statement itself, magistrate is satisfied that there is sufficient ground for proceeding further and he can straightaway issue process to the accused. But there can be cases where he is in doubt. Therefore, he conducts an inquiry under section 202 CRPC corresponding to section 225 BNSS. And after inquiry, if he is satisfied that there is sufficient ground for proceeding, then only he will issue process to the accused. If he is not satisfied that there is sufficient ground for proceeding, he will dismiss the complaint under section 203 CRPC, that is under section 226 of BNSS. So sufficient existence or otherwise of sufficient ground for proceeding is the yardstick on which the process to be the commencement of trial or the termination of the private complaint, etc., takes place. So the Supreme Court held that. Now we are on the question whether section 200 and 202 CRPC, that is 223 and 225 BNSS, whether it is an inquiry. Supreme Court said, the Constitution Bench of Supreme Court in Hardeep Singh versus State of Punjab, AR 2014 Supreme Court 1400, 5 judges, AR 2014 Supreme Court 1400 held that, of course, it is an inquiry because inquiry in the sense that evidence is taken. The sworn statement of the complainant and his witnesses is recorded, which is in a way evidence. But strictly it is not evidence because evidence has to be taken only in the presence of the accused. Here accused is yet to be summoned. He has no right to be present during this inquiry stage under section 200 or 202. He is yet to be summoned. That is why I told you Supreme Court has taken the view that even if he happens to be present in court, he can only watch the proceedings taking place. He cannot participate in the proceedings. For that, he has to be summoned. An invitation has to be given to him. Please appear before this court and address the court. then only he gets the locus standi to address. Therefore, Supreme Court held that evidence is now, as you know, under section 273 CRPC, corresponding to section 308 of BNSS, evidence has to be recorded only in the presence of the accused, except in a rare instance where accused disturbs the proceedings. Accused is disturbing the proceedings. Then only, otherwise, he has a right to be present when evidence against him is being taken. Therefore, Supreme Court said that this is what is revealed during an inquiry under section 2. It is an inquiry, no doubt, but strictly it is not evidence. Therefore, it is when during the subsequent trial of the case, this statement of the witnesses, of the complainant and his witnesses, can be used only for the purpose of corroboration. Can be used only for the purpose of corroboration during the subsequent trial. Because this is a statement recorded behind the back of the accused, at a stage when the accused is yet to be summoned. Therefore, though it is an inquiry, what is recorded is not evidence, because accused is absent. Therefore, this can be used only for only use of this material, though in a loosely it can be called evidence, is only for corroboration of the evidence when the particular witness is examined during trial. That's what the Supreme Court Constitutional Bench held. Now we come to question number 6.
Whether pardon tendered to an accomplice by a magistrate under section 306 of CRPC corresponding to section 343 of BNSS is tendered during the course of an inquiry.
See, why pardon is tendered to an accused? Pardon is tendered to an accomplice. Accomplice is a participant, a partner of offense. Pardon is tendered to an accomplice means accomplice is a partner of the offense. He is usually tendered because there may not be any eyewitness. There may not be any circumstantial evidence also. So it will be difficult to secure a conviction of the accused unless one of them is made an accomplice, made an approver. So therefore, there is a device under section 306 CRPC corresponding to section 343 BNSS, wherein the magistrate can tender pardon to an accused, provided one of the accused, provided he confesses his guilt and also confesses the guilt of the other co-accused. He confesses the guilt of other co-accused also, and he confesses his own guilt. In that case, he is rather exonerated from punishment. That is the process of tendering pardon. He is pardoned. He is tendering pardon to an accused. Now, pardon can be tendered not only during the course of inquiry, but also during investigation or trial, as provided under section 306(1) CRPC, corresponding to section 343(1) of BNSS. Therefore, pardon is a procedure which can be conducted during investigation, inquiry, or trial. At any stage, before judgment is pronounced, any of the accused can be pardoned and made an approver. Therefore, it is not only inquiry, investigation stage also it can be done, and during trial also it can be done. Therefore, it is if it is done during inquiry, it is inquiry. If it is done during investigation, it is done during investigation. If it is done during trial, it is done during trial. Yes, please pass on to next question. Once again.
7th question. Is not the co-accused entitled to cross-examine the approver during his examination under section 306 subsection 4A CRPC corresponding to section 343 subsection 4A of BNSS?
See, once pardon has been tendered to an accused, to an accomplice, then the section says, section 306 4A CRPC corresponding to section 343(4)(a) of BNSS says the magistrate taking cognizance of the offence shall examine the accomplice as a witness before him. So once pardon has been tendered to him, he has to be examined before the magistrate taking cognizance of the offence as a witness. Therefore, he has to be examined before the magistrate as a witness. Now, if it is done during the stage of investigation, there are decisions to the effect that there is no inquiry. If pardon is tendered during the stage of investigation of a case, and he is subsequently examined before the magistrate taking cognizance of the offence, that examination which takes place under section 343(4)(a) of BNSS is not an inquiry. It is taking place during the stage of investigation. Investigation precedes inquiry, is it not? So it is before inquiry. Therefore, the co-accused, the other accused persons who are yet to be summoned, have no right to cross-examine the approver. This was so held by Justice Padmanabhan of the Kerala High Court in re CJM, Trivandrum, 1988, Criminal Law Journal 812. 1988, Criminal Law Journal 812. This decision of Justice Padmanabhan, he was a great judge of Kerala High Court. This decision was noted with approval in paragraph 12 of State of Himachal Pradesh versus Surinder Mohan, AIR 2000, Supreme Court 1862. The judges were M.B. Shah and Justice K.T. Thomas. Justice M.B. Shah is the author of the judgment. The verdict of Justice Padmanabhan of Kerala High Court was noted with approval in para 12 of State of HP versus Surinder Mohan, AIR 2000, Supreme Court 1862. Therefore, if pardon is tendered by the magistrate during the stage of investigation and his examination is taking place during the stage of investigation under section 306(4)(a) CRPC, the co-accused who are yet to be summoned before the magistrate have no right of cross-examination. This is what the Justice Padmanabhan held and approved by the Supreme Court also. But if pardon is tendered after cognizance of the offence and appearance of the co-accused in response to process, see, after cognizance of the offence, this is the investigation. After investigation, the police will file a police report. After filing the police report, the magistrate will take cognizance of the offence and conduct an inquiry. If during that stage pardon is tendered to an accused, the co-accused are already before court. The other accused, whom he betrayed, are already before court. Therefore, they cannot be denied the right of cross-examination. Now, here, the Kerala High Court, there is utter confusion. There was utter confusion. In State of Kerala versus Monu Surendran, 1990, 1 KLT 53, Justice U.L. Bhatt, who was one of the greatest judges our Kerala High Court, Kerala State has produced, Justice U.L. Bhatt and Manoharan, authored by Justice U.L. Bhatt, took the view that the other co-accused are entitled to cross-examine the approval because they are already before court. They cannot be denied the right of cross-examination. In fact, the learned judge, Justice Bhatt, followed Sanjay Gandhi versus Union of India, an observation by Justice V.R. Krishnaiyer in Sanjay Gandhi versus Union of India, AR 1978, Supreme Court 514, AR 1978, Supreme Court 514, and 514. Subsequently, in Sitaram versus State of Jharkhand, AR 2008, Supreme Court, rendered by Justice Arijit Pasayat, it was held that in that case, not specifically raised and considered, but in that case, the co-accused who were already before court were given the right of cross-examination. Now, what happened in Kerala High Court is that Monu Surendran, which according to me was correct, had correctly held that co-accused have a right to cross-examine the approver if they are already before court pursuant to summons, was unfortunately overruled by a full bench of the Kerala High Court, to which I was also a party. I was also a party to that full bench. Because in the light of Sitaram versus State of Jharkhand, that decision overruling was that Monu Surendran was not correctly overruled. Sitaram Justice Arijit Prasad's decision, I respectfully submit that Monu Surendran was not liable to be overruled in the light of Sitaram versus State of Jharkhand. Unfortunately, this is what has been held. Now, you may just remember, take the case of a private complaint, warrant trial case. Private complaint, warrant trial case, interpreting section 244(1) CRPC corresponding to section 257(1) of BNSS. In a private complaint, warrant trial case, after the appearance of the accused, there is a pre-charge examination. Examination of the prosecution witnesses before the framing of charge. This is called pre-charge examination. During the pre-charge examination, since the accused are already before court, interpreting section 244(1) CRPC, the Supreme Court held that a right of cross-examination cannot be denied to the accused who are already before court. And if a right of cross-examination is not made available to the accused, he will be no more than an idle spectator. This was the expression used by Justice T.S. Thakur in Sunil Mehta versus State of Gujarat. 2013, Volume 9, SCC 209. 2013, Volume 9, SCC 209. That is, the court said that if accused have already been summoned before court and they are present before the magistrate, and if evidence is recorded, prosecution evidence is recorded, prosecution witnesses are being examined by the public prosecutor, if the accused are present before court, you can't deny them the right of cross-examination. Of course, it is open to them to avail of that right or not. They may cross-examine the witnesses or may not, or may defer it to the next stage after the charge is framed. This is a pre-charge examination. During the pre-charge examination, they have a right to cross-examination. It is up to them to avail of that right. But you can't deny them the right of cross-examination. Similar is the position here. If the approver is tendered pardon at a stage after the appearance of the co-accused, then the co-accused cannot be denied a right of cross-examination of the approver during his examination under section 306(4)(a), corresponding to section what is that section? I very often get confused. 343(4)(a) of BNSS.
Yes.
Therefore, this is my view. Of course, I am only bringing before you a parallel. If the accused are present before court, and if a witness is examined before them, they have a right of cross-examination. Same is the position regarding an approver also. Therefore, according to me, the full bench decision reported in 2005 Criminal Law Journal 3848, 2005 Criminal Law Journal 3848, to which I was also a party, which overruled Monu Surendran, does not appear to be correct. Now we come to waiting. Why not we continue tomorrow trial?
Yes, sir. Yes, sir.
Because my voice has started cracking.
Yes, sir. Definitely.
So tomorrow we are starting at 11 a.m. tomorrow.
Yes.
Evening I got an inconvenience, personal inconvenience. So 11 a.m. tomorrow.
Yes, sir. Thank you so much, sir, for this most enlightening session. I myself was completely enlightened and enjoyed your session, which was so simple With such simple questions and examples, you were able to elucidate complex topics. And I would quote what you so eloquently quoted: inquiry must always be a forerunner to trial, is what we take away. Thank you so much, sir. I hope the audience and especially students, you will take advantage of this most enlightening webinar. And I again give my deepest gratitude to Justice Ramkumar sir for not
Thank you.
just walking us through the statutory framework and judicial precedents, but also for highlighting the whys and whats of these concepts with such clarity and generosity. Students, if you enjoyed this format and would like us to cover any other such topics, do let us know. In case you had queries regarding this particular topic, you can drop in your queries in the comments and they can be looked into, and sir will most graciously has already informed us that he will look into them in the next class, which is tomorrow, part 2 from 11 a.m. onwards. Thank you so much, sir. And students, continue to read and enjoy these webinars which are being provided by LiveLaw Academy. Thank you so much, sir.
Thank you. Thank you.
Thank you.